appearing in person, represented telephonically by Mr. Fidel. We have the state represented by Mr. Lawson. We have Mr. Cabrera. I'm informed from pretrial services. Concept for hearing with respect to a notice I received earlier today from pretrial services indicating that Ms. Russell refused to complete the intake for. I'm not sure why there's so much feedback, but whomever that might be coming from, if I can kindly have you put your phone on mute. I received a notice that Ms. Russell refused to participate in pretrial services in contravention of my direct and unequivocal order. So, Mr. Fidel, I know you're very new to the case. I'd like to make sure you've had occasion to visit with Ms. Russell. If she at this point would care to sign the intake and to be supervised on pretrial services, and I will go ahead and we'll have her do so, and we'll consider the matter resolved. If not, I will direct her to do so, and if she chooses to refuse in my presence, I will hold her in direct civil contempt, and she will be incarcerated until such time she chooses to participate. So those are the stakes, and as I see it, the applicable procedure in law. Mr. Fidel, have you had occasion to visit with Ms. Russell and discuss what her options might be?
I have, Your Honor, and I, as I understand it, Chris Russell, who represented Ms. Russell at the arraignment, is also present with her at the courthouse, physically present with her, and he was there during the meeting with Mr. Cabrera. And after speaking with Ms. Russell, what I'd like to inform the court about is that I think there was a misunderstanding as far as what the court's orders were. And what I am told is, and obviously the minute entry does say that Ms. Russell shall abide by the conditions of pretrial services. Ms. Russell had not seen that had not seen that minute entry until after she got back from the meeting with Ms. Cabrera. And as I understand it, what had been said at the hearing was, you must call pretrial services by the end of the day. You must check in with them. But Ms. Russell did not understand that she was going to be supervised and what all of the conditions of supervision were. So when she saw them at the meeting with Mr. Cabrera, she was surprised by some of them. And as she had not heard those words from the court's mouth, she was not clear that those were obligations that she had to do. Now, obviously, if the court orders that Ms. Russell must abide by all of the conditions of pretrial services release, then she will, of course, do that.
Mr. Fidel, let's get to the chase, Mr. Fidel. Yeah. That is the order. I find it utterly unpersuasive that a licensed attorney would have had the slightest misgivings as to what my direct order was. However, at this juncture, if I'm to understand that she will abide by conditions of release, that she will participate in the intake, and follow that order, I consider the matter resolved. But if that's not, if she's going to be this difficult to supervise, we're going to have a problem going forward.
Sure, I understand, and Ms. Russell will not be difficult to supervise. As you note, she is an attorney. She understands the obligations. If I could, I would like to be heard on some of the conditions of the pretrial services supervision, and the reason I ask is that I've talked with the folks at pretrial, and I'm told that those are standard conditions. The court is free to add conditions, can remove conditions, and what I would ask is that as Ms. Russell has no criminal history whatsoever, is an attorney, has obviously been willing to attend court appearances, responded to the arraignment in response to a summons, appeared at the arraignment rather, is appearing today on time as required. Her desire is to comply with the court process, go through with the court process, and establish her innocence. And so the conditions that I'm talking about are home visits, surrender of firearms. These are things that are important to Ms. Russell, and I would say I don't think there's a need for them, and the reason I say that is because the purpose of release conditions is to ensure that somebody's going to show up to court and not be a danger to the community. and I don't think Ms. Russell is a risk for either of those things. And so I would ask that the court consider having Ms. Russell be released on her own recognizance, or alternatively to remove those conditions from the pretrial services standard form.
Thank you. That request is denied in its entirety. Ms. Russell will abide by all standard conditions and do so forthwith. Anything further, Mr. Fidel, from your standpoint, sir?
No, I don't think so, Your Honor. As I mentioned, Ms. Russell understands her obligations, and I do not expect that she will be any difficulty with regard to supervision.
Well, time will tell. Mr. Lawson, anything from your standpoint, sir?
Nothing, Your Honor. Thank you.
Ms. Russell, have you understood my direct order, which I believe was both previously as well as now stated with absolute clarity? You will be supervised by pretrial services. You are to report immediately to pretrial services and abide by all standards conditions of release. Do you understand that?
Yes, Your Honor. I would just like to ask, are you specifically making findings pursuant to Rule 7.3C, which you're required to do? Rule 7.2 says that...
Ma'am, you have an attorney to represent you. You are out of line and you are out of order.
How so, Your Honor?
There is nothing further. Mr. Fidel, I would advise to keep your client in order. She is out of order and inappropriate. And notwithstanding your statements that she's going to be needed to supervise, this seems anything but that. And if she wishes to be combative and belligerent and difficult, there's other ways we can ensure her supervision. Mr. Fidel, is there anything further from your standpoint, sir?
No, Your Honor, nothing further.
Thank you all. Good day.